Was anyone here last time we did this here? Where I awkwardly called out like 10 names and no one was here? I was like, your boss, you have just been busted. You're supposed to be here. No, it was super awkward, but I'm glad that you guys are here and stayed and hung around. Our next topic is common ethics issues. So this presentation will help you identify and understand common issues that may arise concerning compliance with the Louisiana Code of Governmental Ethics. It is my pleasure to introduce Mr. Patrick Virgadamo, who is a senior attorney with the Legislative Auditor's Office. Patrick began his career at LLA as a law clerk in May of 2008. I was there too. We started together. Before joining the LLA full-time as a staff attorney in August of 2009. In November of 2015, Patrick assumed his current role as senior attorney. He is licensed as a practicing attorney before the Louisiana State Bar, Texas State Bar, and the Eastern, Western, and Middle U.S. District of Louisiana. Patrick is a certified state agency ethics liaison and certified ethics trainer with the Louisiana Board of Ethics. He is also a certified fraud examiner and member of the Association of Certified Fraud Examiners. Patrick assists the LLA's General Counsel and Human Resources in drafting numerous office policies, such as LLA's leave crisis or crisis leave, military leave, sexual harassment, and professional development policies. Please welcome Mr. Patrick Virgadamo.
Thank you, Lizzie. So the key thing today we're going to talk about, and one of the first things we'll point out, this does not count as your 1 hour of ethics training. You still got to go do that. I do not work for the Board of Ethics. Any information or advice is purely informational in nature. I will say, as far as questions, please kind of be more general in your questions. If you ask specific questions, I'm going to politely decline, because the Board of Ethics is really the only one who can tell you if a specific situation is an issue under the Code of Ethics. Reminder, the Board of Ethics will only give advisory opinions on things that have not happened yet. If you go and ask them, hey, I did this, is this okay? They're going to tell you we can't give you an opinion, and they may tell you, congratulations, you just confessed to a violation. So the key thing in all of this is, and you'll just see in any of the audit reports that get issued by our office, anything that's a potential issue of the Code of Ethics, it's always going to say only the Board of Ethics can make that determination. So they are the person you should reach out to. The key thing to understand, though, is anyone who is subject to the Code of Governmental Ethics has a right to ask for an advisory opinion from the board. I will tell you, it's going to always be fact-specific, and as the board changes its membership, the answers could change, and the law is constantly evolving. So when in doubt, this is definitely the area of law you want to ask for permission and not beg for forgiveness later. So we're going to talk about some of the things, and I think from a standpoint of, for audits, this kind of feeds into everything else we've been talking about with controls, with Barry and everything, because one of the controls we have for compliance is making sure we're not violating the Code of Governmental Ethics. One of the big things to understand about the Code of Governmental Ethics is its purpose. It's not just to prohibit certain things that we consider to be unethical. It's also to avoid things that appear to be unethical. We want to have faith and confidence in our public officials, our public servants, and all the things that operate in government. And so the whole purpose of this area of law is to put guardrails to basically preserve that confidence the public hopefully has in the jobs we do. We can't really talk about ethics without talking about how it's regulated. And in 2008, after the special sessions when Governor Jindal first came into office, we now have a bifurcated process for ethics. You have an ethics board and an adjudicatory board made up of administrative law judges. Before this, you had ethics, different parts of the same agency were both determining if you potentially violated the law and then ruling whether you violated the law. Kind of like Judge Dredd, judge, jury, and executioner. And so the law now provides the Board of Ethics will actually make those initial determinations, kind of like a district attorney would for criminal violations. They basically do background, they do an investigation, they decide if they think charges should be levied. Once those charges, if they are levied, you go before an adjudicatory board of a panel of 3 administrative law judges, and ethics has to prove their case. And so the idea is you have someone who is not potentially biased by the investigation making a determination on whether or not a violation actually occurred. Now, the board itself, there were recently a lot of changes. After the 2024 session, they were actually 4 additional members were added to the Board of Ethics. You have now 15 members. Each of them serve a 5-year term, which is why if you're asking for an advisory opinion, as these people cycle off, you have new people on the board, which means different people may reach different conclusions on different facts. And so you have 9 people that are appointed by the governor, 3 that are elected by the Senate, and 3 that are elected by the House of Representatives. In getting into this, ethics is one of those areas where you really need to understand the terms to understand what is required or prohibited under the law. So some important definitions we'll kind of go through kind of quickly just so we can get the lay of the land are, what is a public servant versus an elected official and public employee? They are different. And so when you see that term, you need to know who does the restriction apply to. Immediate family, who are those people of that public servant? Things of economic value, agency head, substantial economic interest, and prohibited sources. We'll see why those are important as we get into the actual things that we should be looking at for ethics issues. So public servant is the broad term. When you see public servant, this means public employees or elected officials. And so the law has different requirements in some cases for a public employee versus an elected official. You'll see a lot of times this is like with prohibited sources because of the nature of campaign finance, receiving campaign finance contributions. So there are different restrictions for that elected official versus a public employee. But if you see the term public servant, it includes both. It is the broad term and includes basically anyone that's a public employee or a public official, elected official. Now, elected official, most of us think of elected official, we think, oh, we went to the ballot box, we voted on these people. So that's an elected official. It is, but it's not just those. Classic example for our office is the legislative auditor. Under the Constitution, he is elected by both houses of the legislature. He is an elected official for the purpose of the Code of Governmental Ethics. He isn't for campaign finance, but he is for ethics. The other one that you may see is if you see like a board or commission, sometimes a position on that board or commission may be someone elected from an association. That person is an elected official for the purpose of Code of Ethics because they're elected by their association. That is the appropriate electorate for the purposes of them getting their office. They're not appointed, they're actually elected under how they're established. Oh, sorry. Public employee, this is the one, it's caused a lot of consternation because it's a pretty broad term. One thing I would tell you if you're writing notes or if you printed out slides, circle this, compensated or not. It doesn't matter if you're paid or not, you can be a public employee. You can be a complete volunteer doing everything of your own free will. It's still, you can be a public employee. The key things are, if you're an administrative officer, someone who is not an elected office, but you're basically doing an administrative role heading up a agency, you're going to be a public employee. That's a no-brainer. If you're someone appointed by elected officials, so like your departments of secretaries or department heads in a municipality, you're not elected, but you're appointed by an elected person, you're clearly a public employee for the Code of Governmental Ethics. Where it gets a little more broad is engage in the performance of governmental function. As Angela talked about in her example with Bulldog and with LSPCA, you have a lot of things now where these entities or individuals are carrying out functions under contracts. So for the purpose of the contract, they could be a public employee within the confines of that contract. And so it's one of those things, when you do contracts, you want to make sure you address those potential concerns. Usually it's maybe as simple as just having a clause in your contract that that contractor who's doing those functions for you is going to follow the Code of Ethics. It also includes people under the supervision or authority of elected official or other employee. Could be your volunteers. So people who basically, they're showing up on a weekend to do something for your agency or for an event. They're a public employee for the purposes of that event. Agency is the one I think people get confused. There is a distinction between governmental entity, which what we normally think of when we say agency, you're thinking of your governmental entity, your municipality, your police jury, the actual governmental entity. Ethics has a different term, uses this in a different term of art. You have a governmental entity, and an agency could be the component part of that governmental entity. So for the purposes of the Code of Ethics, your agency could depend on where you are in the organizational chart. If you're someone who is a custodian at a major state agency, your agency for the Code of Governmental Ethics may just be the custodial department, not the entire governmental entity. And so this is why you always want to go to the Board of Ethics if there's a concern of a potential violation of engaging in transactions, which we'll talk about. You want to make sure you know who is your agency. And so the only one who can really tell you is the Board of Ethics. They're going to look at what do you do, what is the organizational chart for your governmental entity, and kind of make that choice. The key is the higher you are up in the food chain of your org chart, the more likely the entire governmental entity is your agency. The law specifically for local government says that the mayor and a board of aldermen, the entire municipality is your agency. So the governmental entity and the agency are one and the same. They make distinctions sometimes for people if they're in the police department, and there are distinctions that board has made whether it's an elected or an appointed chief. So in all those cases, if there's a potential violation, the first thing you want to find out is, after you know you're a public employee, what's your agency? Now, agency, the term is not just a consistent term. So for state government, the executive branch, the way it's defined is what department, board, commission, or even subunit within that department you are. So if it's the custodial department of LDH, the custodial department of LDH is your agency, not all of LDH. A judicial branch takes a little bit different curve. If you're an employee of, say, the district court, the way the law defines is your agency is your court, but it's any courts that review your decisions. So it would be the courts of your appellate court and the Supreme Court. It does not include judges, because judges are not subject to the Code of Governmental Ethics. They have their own ethics code that is enforced by the Supreme Court. Legislative branch for us guys is actually pretty easy. It is the house or agency that you are employed by. So for everybody who works for the LLA is our agency. There is no subparts. The LLA is both the governmental entity and our agency for us. Local government, you're going to be much more like the executive branch. We're going to look at where are you within the org chart? How is it broken up? Sheriffs, for example. A lot of sheriffs have a civil side and a criminal side. And the criminal side is usually more like corrections and things of that sort, whereas the civil side is more like civil processing, serving, civil processing, and things of those sorts. Where you fall on that side may determine which side of the sheriff's office you can potentially have any other dealings with. And so your agency is going to be important. Agency head is going to be the person who's the head of that agency. But remember, agency is not the same in most cases as governmental entity. So a governmental entity like a municipality can have numerous agency heads, because each department head is an agency head of that department. Everybody who's maybe a supervisor under a component under a department may be their own agency head. That's important because for nepotism restrictions, you look at the agency to decide whether that agency head has immediate family who is in the same agency, not necessarily governmental entity. Immediate family. Anyone who's ever seen Meet the Parents, I always like to say, this is your circle of trust. These are the people that will always be and forevermore be in that group. The law makes it clear and lays out who these people are. If they're not in that group, they are not your immediate family for Code of Ethics. It's important to know who your immediate family is because restrictions often apply to both you and your immediate family, but it also becomes important for nepotism because once you have someone who's an agency head, their immediate family is generally prohibited, and we'll talk about it a little more detail from working under that person. There are some exceptions for someone who's already been employed for at least a year before that person becomes an agency head, but there's some other rules you need to follow, which we'll talk about. Now, this chart should help you. If anything you take from this, take this page, print it out, because if you ever have a question of if somebody is the immediate family member of somebody, look at this chart, put them in that chart, and see if they're on this chart. So, public servant, you have the public servant. Their spouse is always going to be their immediate family. Their children are always going to be their immediate family. The spouses of their children, so their son-in-law and daughter-in-law, are always going to be immediate family. Their parents are always going to be immediate family. Their siblings are always going to be immediate family. What may or may not be is their brother-in-law and sister-in-law, because you'll notice this chart is pretty lopsided and we haven't finished it. The spouses of your siblings are immediate family. Your spouse's parents are immediate family, so your father-in-law and mother-in-law. What are not immediate family are your brother-in-law and sister-in-law that are the siblings of your spouse. I would assume at some point someone wanted to make sure they weren't included because they were doing contracting, and so it is very one-sided. But if they're on this group, they are considered your immediate family. Great. You'll notice grandparents, nieces, aunts, uncles, grandparents, great-grandchildren, cousins, none of these people are going to be your immediate family. They may be family, and they may be something that gets disclosed as a related party transaction in your audit, but for ethics purposes, only these people, by law, are your immediate family. And it's important because the restrictions apply to them and only these people. So think of economic value. I always like this one because it's money or anything having economic value. Very circular definition. I don't know if I like the fact that they use economic value to define itself, or the fact that they want to make sure money is not included, because does it have economic value? The easiest way to understand this, though, is it doesn't have to be tangible. It can be intangible. So discounts, things of those things. There is no minimum value. Tickets, complimentary admission, which we'll talk about some of the things you need to make sure on that. Discounts, tips. I don't know about you. I've never been offered a tip. I've been suggested tips, but never given a tip. But these are things of economic value. They have value. One of the questions we get a lot is gift cards. Can you spend it? Yes. Well, it has economic value. Substantial economic interest. This is one we'll talk about when you have a transaction. There's prohibitions of that. There's what they call the 25% rule, where you can't have a legal entity that you or your immediate family collectively own more than 25% of. That is different than substantial economic interest, which is part of the restrictions for participation. The easiest way to understand substantial economic interest is that you have some greater benefit than a general class of people. The best example I've ever heard for this is you have someone who's a alderman for a municipality, and they have an ordinance coming up that's going to change zoning. If the zoning ordinance affects the entire town, then they don't have a substantial economic interest because they are affected just as much as anyone else in the town. If the zoning ordinance is affecting the block that they live on and they own, like, say, 25% of the block, well, congratulations, you have a substantial economic interest, which means, as we'll talk about in a little bit, you got some participation restrictions that you have to worry about. Things it does not include, though, and the law has made it pretty clear on this, interest that a public servant has in their own position, things that arise out of the nature of the public employment. So anyone who's a board member of an alderman of a Larson Act municipality knows the only way you change your pay is by adopting an ordinance adjusting your pay. Well, to adjust your pay, you have to vote because you have to have a majority of the entire board to do it. What the law says is that is not an issue. It's not a substantial economic interest, even though it directly only affects the alderman. That's an exception. They're allowed to vote on their own pay because the law requires it. What they can't do is do it in regards to another position. So if their position, they're also the appointed member of a board that is under the jurisdiction of the board of aldermen, they can't vote on their own pay in the other position. They have to recuse themselves in that situation. The exception only applies for them in the position they're taking action in, not for another position that they may have separately. Also doesn't affect if they allow themselves to nominate or vote for themselves. A mayor pro tem of a Larson Act municipality is elected by the members of the Board of Aldermen. They have to be able to nominate and elect amongst themselves. So the law says if by law, legislative rule, or some provision of your home rule charter or local laws, it requires that a member of the body be elected to fill in some position, they're allowed to do that. It's not an issue.
You need elected official, hold a position on a board and receive compensation?
That gets tricky. It depends, because you also have situations where there may be restrictions from you being on the other board anyway because of dual employment. Because if it's an incompatible office where you have direct oversight, it could be an issue. The most likely situation is where those elected officials are ex officio members. So like if you have a board or a commission that's created by a municipality, you may have aldermen who serve on those boards or commissions just so that they're there. They may be voting members. They usually don't necessarily get compensated. It's usually part of their role as an alderman. But usually pay positions, you have to look at it. There are situations where it might be okay, but in many cases, it's usually for like an elected official, they usually don't get additional compensation. Those costs are just assumed because it's usually more like an ex officio thing. It's part of their duties as the elected official. Now, finally, any interest you have as a member of the general public. Again, like if you have the ordinance that affects the entire town, it affects everybody equally. So you have no substantial economic interest because your interest, kind of going back to the general definition of it, is you have no greater benefit than anybody else would have in that specific thing. Oh, there we go. Prohibited source. This one's important because there are restrictions for compensation and for gifts. Prohibited sources, if the easiest way to think about this, these are people because of what they do or what they're regulated by you and your agents, your governmental entity, can't give you things and you can't receive things from them. The first one is someone who has or is seeking contractual business or financial relationships. So a vendor, your vendors of your town, your police jury, you cannot go work for them and you can't receive gifts from them. Someone that's a lobbyist. And again, lobbyist is a very big specific definition. It's someone who's compensated to go and provide influence things before elected body. So paid lobbyists are restrictions. They're prohibited sources. Someone who conducts activities that are regulated. This is the one that's kind of the broad one. And then someone whose substantial economic interest can be affected by the performance or non-performance of your duties. These two have been used in the past. One of the examples where you had I always like the little poor librarians in St. Tammany Parish. The question was, they had put on this summer reading program, and somebody goes, "Can we go bake these ladies some pies and go bring them to them?" And ethics had to tell them, unfortunately, no, because you're not there when they eat them. That would be you're a prohibited source because you're members of the public. They're the ones, if they do their job, you're the taxpayers who use the library. They can't receive this. There's some changes, and we'll talk about that. But the key thing is, you also have situations like an assessor or someone who has like a CPA, and so they do taxes for people. What they basically have said is, if you're an elected official in a parish, you can't do taxes for people in your parish, but you could potentially do them in other parishes. So like a neighboring parish where they're not your constituents that are affected by you going assess their property. I think, if I remember correctly, it was an assessor who was the CPA. You can do the taxes elsewhere. You can't do it for people who are your constituents because they are affected by you doing your public job. And so it could look like a kickback. So we've talked about some of the definitions, but now we're going to get to why it's important. Why it's important to understand those terms and some of the things we should be looking for in our day-to-day things so we don't get audit findings, so we don't have issues for compliance. So to kind of give a preview of the things, we're going to talk about prohibited payments, participation restrictions, transacting or contracting with agencies, nepotism, post-employment restrictions, annual ethics training, which is important because you still got to get your hour if you haven't gotten it, and prohibited gifts. So prohibited payments, the general rule under the Code of Ethics is that a public employee cannot receive anything other than their salary and their enumerated benefits. You can't get additional monies beyond what you're approved to get as your salary and your compensation. The idea is you're paid, hopefully paid well enough for what you're doing. We all know it, maybe not. But you can't go and take additional money for doing things you're already compensated for. Examples, you can't get finder's fees. One of the things when we present sometimes to the Governor's Office of Homeland Security, you would think, well, how are you going to ever get a finder's fee? Well, if you're an entity who deals, say, with disaster recovery stuff, and someone says, hey, who did, say, the city of New Orleans use for their debris removal contract? And you tell them, oh, they use X and so contractors. And so they go and they contract with X and so contractors, and they come back to you and say, hey, thank you for getting me business. Here's some money. No. You also can't get additional monies derived from doing your job or information. A lot of times as public employees, we have access to confidential and secure information that we otherwise would never have access to. Just like in the private sector, you can't take that and go, let's say you come up with, as part of your job duties, a spreadsheet that you put in macros and everything, and basically it's the next best thing, and people, if they use it, can easily get their grants approved. You can't go off on the side and take that spreadsheet you created and were paid for as a public employee and go sell it to other people because it was derived from your job as a public employee. You also cannot receive compensation from prohibited sources. This is the one that people need to be very, very aware of, because vendors, if you have a night job, if that night job does a contract with your agency, congratulations, you got to stop working. But for one of the two. There used to be a provision where the board kind of read it into the law that if you were paid salary, you weren't participating in that contract, they would basically look the other way. Then they realized that's not what the law says. So they asked the legislature to put an exception. Well, what the legislature essentially did was say, your spouse can have a job with someone who's a prohibited source, but there are restrictions. You got to make sure they're not specifically working on that project. Their compensation is not affected at all, like their salary. They're not a director or head of that entity, and you have to report. You have to disclose that information. That's the limited exceptions put in there. So as a public employee, you still can't receive compensation, even if it's completely different. Like, you can't go cut the grass for someone who's a prohibited source because you can't get paid, because the idea, going back to that purpose, yeah, there's really no issue ethically because you're getting something unrelated to your public activities, but we don't want the appearance, because it kind of goes to the old wink, wink, nudge, nudge, University of Alabama, you got a charger, here you go. We want to make sure there's no kickbacks. And so to avoid any appearance of that, you're not allowed to provide compensated services to someone you can't get gifts from, because we want to make sure it's above board. Now, prohibited transactions, participation. We as public servants cannot participate in any transactions or activities with our agency that we are specifically involved, our immediate family, or anyone who has substantial economic interests. That basically, without going into all of these, if it's someone where it's an entity you're an officer of, a nonprofit, if you're the officer of this nonprofit, that nonprofit, you have to stay out of anything with that entity and your agency, because we don't want it to look like they're getting favoritism because of your director position on that entity. Can't be someone that you're negotiating prospective employment, because then it looks like they hired you because you were able to get them the deal. My favorite one is someone who owes you money. So that college roommate who still owes you money and know they're not going to have money to pay you unless they get this contract with your agency, run away. Do not participate, because then it looks like they got that contract because you knew they were going to then have money to pay you. And so I think the example Jennifer always says is, if it doesn't feel right, it probably isn't. And so when in doubt, recuse. You also can't have someone, this is where that 25% comes in and roll again. If it's someone that has a contract that you or your immediate family collectively own 25% or more, you need to make sure that you're not involved in that either, because then they become an entity that's just as though they're immediate family. Recusal is important because there is distinction between elected officials and everyone else, appointed and public employees. Elected officials can recuse themselves. They have to announce that they're recusing, that they have something that requires them to recuse, but then they can debate the issue all day long. They can tell you why you should vote for it. They just can't vote for it. The appointed and public employees have to recuse themselves and cannot participate at all in the deliberations. In fact, I would suggest leave the room. Basically, the idea is it's a full recusal. Only elected officials, they're still given the ability to still talk about why that law is good or not. They just can't vote on it. They have to publicly announce they can't just not vote. They have to announce that they're recusing themselves, but they can still deliberate. Transactions are different than the participation because you can not participate in something but still be part of a transaction. So there are two separate restrictions. The transaction contract basically says you can't contract with your own agency. Your immediate family can't contract with your agency, and legal entities that you and your immediate family collectively own more than 25% can't contract or participate in transactions with your agency. Boards and appointed members of boards and commissions, it's a even heightened restriction. They are not allowed to be in any way interested in anything to do with their board or commission. Small municipalities, there's actually an exception. So if you're a municipality of 5,000 or less, a lot of times it's going to be rule. Somebody on the board of aldermen may be the only person who owns the local grocery store. And so they may be the only one you can get supplies for. There are provisions, but to do this, you have to have a plan that's approved by the Board of Ethics to do it. It's not just an exception where you can go do it. You got to show the Board of Ethics through a plan that you meet all the criteria, you're doing all the things required, you're recusing yourself from the actual votes, and they approve that plan. So you should have documentation of that approved plan in order to use that exception. So some common violations to really understand transacting with your agency or contracting, because most people think, oh, I just won't go do a contract. But it's not just that. Bidding on contracts with your agency. Most people think, well, it's sealed bid, so it's fair to everyone. Why can't I just bid on that contract? You can't, because that would be engaging in a transaction or contract with your agency. Just the bid itself is enough to be a violation. You don't even have to win the bid. Bidding is engaging in a transaction. Performing compensated services for your agency. There is an exception that says if you want to wholly volunteer for no cost to donate services to your agency and go do it for them, you can do that. Make sure you document you didn't get paid for it, but you can't receive compensation for doing additional duties for your agency, because then you're engaging in a transaction with your agency. You can't bid on surplus property. We get questions a lot. Hey, can our public employees bid on this vehicle that we're selling as surplus? Well, if their agency is the one selling the car, no. If the person doing the auction is doing it for their agency, still no, because it's still their agency. But again, it goes back to what's their agency. So if they're in this one department on the other side of the governmental entity, maybe, but I would go to the Board of Ethics before you do it. And then renewing contracts, the law basically says if the contract was already in effect, so you had a contract that was in effect and then you go work for an agency, or your immediate family member goes work for an agency, that contract can continue in effect under its terms. They just can't take steps to renew it. The law has changed a little bit in this last session to have some certain things where if it's completely at discretion of the governmental entity and you're not involved in it in any way, you might be able to do it, but I would say don't do it without getting Board of Ethics to say, yes, you meet that exception. You can't renew the contract. You can't amend the contract to increase the cost or to extend it. Basically, the idea is we're letting you keep the contract because you already had it before it became prohibited, but you can't renew it because the prohibition now comes into effect. It's important to note because you could have a pre-existing contract, or if you have a situation where you own less than 25% of the entity, so that it's not prohibited, but you're still getting money from your agency through a contract. The law actually has a specific disclosure that you have to make under 42:1114, specifically when there's a situation where you get money from your agency. The thing ethics always likes to point out is that disclosure doesn't make it okay if it was a violation. So if you really own more than 25% of that company, congratulations, you've just admitted to a violation. But it is one of those ones where you have to disclose that. Again, the idea is we want to make it clear. There's no violation, but we want to make it clear, you got money from your agency, but it was because it wasn't a prohibition. Either it was an existing contract or you own less than 25% of the entity. So nepotism. Basically, to summarize it for you, the immediate family members of an agency head can't work for the same agency. Again, that doesn't mean they can't work for the same governmental entity, they just can't work for the same agency. If they were already there for at least a year before that person assumed the role of agency head, there is an exception, but in all cases, under any of the exceptions, because there's some additional exceptions for certified teachers, nurses, and things at hospitals, for hospital service district hospitals. In all cases, if you're doing the exception, there is a requirement of a disqualification plan. So even if they were, sorry, I keep walking away, sorry. The exception basically says, if there's an exception, you still have to have a disqualification plan that shows that that person who's the agency head is not going to supervise them directly. Whether it's the assistant that's going to supervise them, however they're going to do it, ethics has to sign off on how you're going to address that still potential conflict of the agency head being an immediate family member. And again, remember, immediate family member, we've had questions sometimes come before ethics or us. The grandparent is the agency head. Can their grandchild go work for the agency? Yes, because they're not an immediate family member. Because remember, it stops at kid, not grandkid. That doesn't mean you still shouldn't potentially have issues, and you may have internal policies that restrict it more than ethics does. You may say, oh, we don't care if you're a grandkid or not come to work, because we don't want that. Post-employment restrictions, we get a lot of questions about this. People retire, they want to come back to work, especially when the agency realizes we need that knowledge. You can't contract with your former employing agency to do the same services you performed under a contract for 2 years. You can't participate in compensation in matters you previously worked on for 2 years. The key thing is there, we don't want someone leaving their employment and going work for the other side. That's a private entity for 2 years. We don't want you to retire or leave and come back and do it on a contractual basis for 2 years, the same job, especially the higher up you are, because then it looks like you used it to maybe make more money. There are additional restrictions for agency heads. They specifically can't do any transactions with their agency for 2 years. So it doesn't matter if it's what they worked on or not. We don't want them going before their former agency because it looks like they may have undue influence. Now, it's important to note for post-employment restrictions, they do not prohibit employment or reemployment with a governmental entity. The question we get a lot is someone retired, they want to come back, we want to rehire them to do this, but it's not been 2 years. Can we do it? For Code of Ethics, there is no restriction. If they're a W-2 employee, the restriction doesn't apply. You do need to get with your retirement systems because if they retired, there may be some restrictions or things that you need to do. But ethics is not a problem. If you're going to make them a 1099 contractual employee, then you need to make a determination, is this the services they provided? You may want to get ethics to say, okay, here's what they did, here's what they're gonna do, is this okay? And ethics gives you an opinion saying yes, keep that in your files. And so for that 2 years, they can only do contractual stuff that they didn't perform before they retired or left. Ethics training. Every year, anybody who's been a public employee for a while knows this, you have 1 hour of ethics training each calendar year. And schools have problems with this because they're on a school year, but it's still a calendar year. So by the end of December, you have to have had 1 hour of ethics training. Elected officials that are newly elected also have to have an additional hour of campaign finance disclosure training in each term of office. Political subdivisions, this is important to know for the training purposes. You are required to have someone designated as your political service ethics liaison. They get 2 hours of training every year by the Board of Ethics, and they are the person who can proctor your training if you need it to be done. If they become a certified ethics trainer, they can actually provide training to your people, but they are the person who disseminates and is your liaison with the board for questions and things that come from the board. They get the 2 hours of ethics training, and if they perform training, here's one for you guys for your public records. Any records of trainings that they put on for your agency need to be kept for 4 years, at least 4 years. The board's rules for ethics training say ethics training attendance records have to be kept at least 4 years. The key thing with that is you got to get your hour of training. This doesn't count. We do have some more information on this as well as the other required trainings in a white paper on required trainings. Has links to this, links to sexual harassment, cybersecurity, and some of the other ones that are required every year or at least every 3 years. So you want to look at those. That political subdivision liaison also can give training to as I said, the proctor. They have a video. They can basically put it going, do a sign-in sheet, and your employees get it. They report back to ethics, and that gives you your hour for those employees who sit there and watch it. Of course, they can also go to the Board of Ethics website and do it. What I would suggest, because as part of those agreed upon procedures, your CPAs are usually looking at testing, do you have certificates for people to show they did ethics training? Have someone, probably your liaison or your HR, have a record of all the certificate, have your people give a certificate that shows they completed training, so that way you have a record that, say November, you're checking, oh, I don't have a certificate for you, go do the training. And so that way you don't have potential findings in your audits of someone not having ethics training. Prohibitions on gifts. This is important for us. Generally speaking, prohibited sources cannot give us things of economic value. We can't receive gifts from those people. We also can't receive, as we said earlier, additional things for doing things we're already compensated for. But there, as in all things in life, there are exceptions. And in Louisiana, food and drink's one of those. Basically, under the we'll talk about the food and drink exception, promotional items, which a lot of people get confused for economic value as that it somehow has a minimum value. It doesn't. Promotional items do for the exception, but economic value, 1 penny has value. And then conference travel and complimentary mission. So prohibition on gifts, we can't receive things of economic value or solicit them directly or indirectly from anyone who is a prohibited source. We are, however, allowed to receive food and drink if the individual or their designee giving the food or drink is present and the total amount doesn't exceed the current limit, which as of July 1st is currently $81, which does not include tax and gratuity. That amount for group calculations is done differently. Whenever someone's going to give food and drink to a group of people, what the board and the way the rules are set up is they look at how many people are invited. They take how many people were invited, how much was divided by how much was expended, and that gives you your total per person. And if as long as it's below 81 or below, you're good. Conferences and conventions, whole different thing. If it's a meal provided at a conference, there is no restriction on the amount. That conference can give you filet mignon if they want. You're probably paying a lot to go to that conference, but there is no amount at that conference. There is also an exception that allows in groups of 10, a person, even if they're a prohibited source, can take a group of people to a nearby restaurant and provide food to them. And it's considered part of the conference. So if someone wants to, like a vendor wants to explain to a group of 10 people or more why this is the new thing, best software out there, they can do that. It still has to be, they can also provide reasonable travel to it, but it's got to be in the vicinity. So if you're in New Orleans, there's some good restaurants they can take you to. But again, it's got to be in the vicinity and a group of 10 or more.
$81 per event.
Per meal. So you breakfast, lunch, dinner. Each one of them is 81. Now,
Patrick, I have a question.
Yeah.
Do contractors for state agencies require ethics training?
depends on what they're doing as a contractor. Again, if they're considered a public employee, they do. But if they're a contractor themselves and they're providing just contractual services, probably not. But if there's a question, they want to ask the Board of Ethics. Because, example, when they were constructing this building, it's one of the ones we always use, the architect in that case, because what they were doing was considered, the architect wasn't just designing the building, they were handling all the change orders, they were acting as the agent for the state in the construction. The question in that case was, could the brother of the architect bid on the project? And they're like, well, he's an architect, he's a private person, he provides services to everyone. And well, Board of Ethics says no. Because they're not just doing architectural services, they are acting as the agent. They are doing the change orders, they're negotiating all the stuff, they're attending the meetings. They are, for the purposes of that contract, a public employee. And so I would always say, if there's a situation where you're providing things that are a governmental function, ask the Board of Ethics, because they're the only ones they can tell you. There is a new holiday food exception. Historically, the food and drink exception said the person had to be present. What they did in the law, and we still haven't gotten a lot of guidance on this, is basically say for every recognized religious or state recognized holiday, if someone wants to give food, like a gift basket of food, they can give it to that person as long as it doesn't exceed the current meal exception, which is $81. I would assume with Christmas coming soon and Thanksgiving, we will be getting some guidance from the Board of Ethics on this. And so if you have an ethics liaison, they should be getting that information to disseminate to your governmental entity. But it is new law that just became effective this past summer. No, for that, it is per holiday for that. No, there is no, the only thing that has an annual limit, there is a separate exception for teachers, for student gifts. There's I believe it's $75 a year total. And I think they're looking at tweaking that because of inflation. But the key thing is the meal is per meal. There is no annual limit on that. Lunch and dinner.
3 days a week.
3 times a day. Yep. And the key thing is, the ethics always points out in the liaison training, if the person giving it goes over the amount, they're the violator, but you're still going to be involved in the news story when it comes out. So a gift, promotional items is another exception. The way one of the persons who used to work at Board of Ethics, Mike Dupree, used to explain it, and I thought it was a great way. If it's something that's going to end up on your floorboard, congratulations, you can keep it. If it's something you want, you probably can't have it. But essentially, the item has to be permanently imprinted with the logo of a business or organization. It also has to be something that has minimal value, and this is where people get confused with economic value having no minimal value, but the promotional item does. And it can't have substantial resale value. The examples, like the extremes, an iPad. Yes, it could be permanently laser engraved with the logo of somebody. You still can't have it because you could slap a case on it and I guarantee somebody will buy it even if it's got a logo on it. The examples of things, and this kind of goes back to the, if it goes on your floorboard, you can keep it. Things that are examples of this are going to be pens, pencils, notepads, t-shirts, things that you see like out on the tables at vendors at a conference. Those are the things you can have. If it's something more substantial, I would say don't accept it unless you first get ethics to say it's okay. They've kind of gone back and forth on things. Historically, like those fold-up chairs people use for tailgating, they said no. Because everybody looks for those, because if you got a tailgate, you know they go missing. But historically, a roadside kit thing was considered okay. As long as it had the logos permanently embossed on it, like the little inflator thing, they allowed those. I would always suggest, if it's something more than like a keychain, notepad, or a t-shirt, you may want to ask ethics before you take it, just to be safe. Complimentary admission. Again, we talked about it doesn't have to be tangible. What we mean by admission is basically when someone's allowed to attend an event that other people have to pay to attend, there are exceptions where you can be allowed to receive complimentary admission. We put it in big bold because they put it in big bold since 2008. It cannot include sporting events. And note, this is different than lodging and travel, which is a separate exception, which we'll talk about. But essentially, if you are attending a civic, nonprofit, educational, or political event where you're a panelist, or you're being honored, or you're assisting someone who's on the panel, there's an exception where we're gonna obviously let you go attend that event without having to pay to be honored or paid to speak at an event. And so in these cases, as long as you meet the exception, and I would make sure you have some documentation if someone's attending it, they meet this. There is no reporting requirement for this exception to ethics. It is different than what we're going to talk about for educational travel. But in the case of where you are the honoree or things, examples of things you probably want to keep in your records, copy of the agenda where it shows you're a panelist or the honoree. So that if there's a question a year from now or your CPA asks, hey, why did so-and-so go to this event and didn't pay? Well, here you go. Here is the thing showing they were on the panel or they were honored. Here's the exception, no questions. You can also accept it for fundraising events of educational institutions and nonprofit organizations doing educational programs. There's not a lot of guidance on this, but a lot of this was created to go attend things like TAF, things of that sort, where they're putting on events, or the arts, where they're putting on events to try to generate money. And usually there's other activities at those events to raise the money. You can accept complimentary admission, lodging, and transportation or reimbursement of those expenses for educational or conference travel. So you don't have to be an honoree or a speaker to get this. But there are criteria you have to meet in order to do this. First, the acceptance of that admission, lodging, or transportation have to be approved by the agency head before they accept it, and they have to report after the fact within 60 days of accepting it to the board. And to kind of show you what this looks like is there is a form that ethics has for this. The top part, the agency head completes before you actually go to whatever that conference is. The bottom part needs to be completely filled out before you submit it to the Board of Ethics, and it's signed by the public servant at the bottom. The key thing is this form shows how much was the admission that was waived, how much was the lodging, and how much was the transportation, like the airfare or mileage reimbursement, whatever it was. They can receive this, but it's got to be done and approved by their agency head before they accept it, and then reported to the Board of Ethics within 60 days. It does not provide requirements if they pay, if you pay, get reimbursed by your agency, and then they reimburse your agency. That is not something that has to be reported to the Board of Ethics. It is different because the governmental entity is the one getting money from the person, the non-governmental entity. It is not you as the individual getting money from them. You're doing your process. And so ethics has said that's not an issue. It is also not an issue if it's a governmental entity that's paying for it. So like if the FBI wants to take some of the people of a law enforcement agency and have them go up to training at Quantico or to a conference that's being held, that's not something that's subject to the Code of Ethics either, because it's not a person providing it. It's the Code of Governmental, it's a governmental entity. Again, remember, this is different than if you're an honoree. The honoree gets complimentary admission under one exception, but if they get lodging and travel, they have to still do this form because the exception for admission only covers admission if they're a panelist or an honoree. It doesn't include travel or lodging. They have to fall under this conference travel exception, which says the agency head basically says it's either a direct benefit of the agency or indirectly benefits us by their personal development. So with that, do we have any questions? I know it's complicated, and again, specific things, really the Board of Ethics is the only one that can tell you. But if there's a question you have from this, or if there's things you have, if you don't want to ask in public, I'll be here during the break. So if you have questions and don't want to ask it in front of everybody, yeah, go ahead, Barry.
Someone wanted you to go over the prohibition on rehiring public employees within 2 years of work.
Okay. Basically, what the law says for a public employee, after you leave employment, either through retirement or just termination of employment, For 2 years, you cannot contract with your former agency to do the same services that you performed while you were employed. You also can't receive compensation for activities and engage in transactions that you were part of while you were a member. So you can't go work for the non-public side of a project you were working on for 2 years that you directly worked on. It does not restrict you from becoming reemployed by the governmental agency or being contracted to do services other than what your services were when you were employed. So like if you were just doing transactional work for your agency and now you've retired and they want to hire you to come do training for your employees, and that was not part of your duties when you were an employee, you can contract with your agency even though it's right within the 2 years, because that's not the duties you did. If there's a question of what your duties were, I would strongly suggest get the Board of Ethics to sign off on it. Lay out, here's what this person's duties were, here's their job description, here's what they're going to be doing. Is this okay? And if Ethics gives you an opinion saying it is, and someone questions it, show them the opinion. Any other questions? Oh, yeah.
So in general, all these limitations also apply to immediate family, correct? Everything?
In most cases, yes. Immediate family, the participation is always going to be the actual public employee because you're the one participating, but the restriction applies. You can't participate in those transactions if it involves your immediate family.
Okay.
But the transaction specifically includes them and any legal entity that you and your immediate family collectively own more than 25% of.
Okay. And one more question. Just for clarity purposes, like, for example, the meal limitation, does that include, like, a reimbursement if your entity is sending you to a contract?
No, the meal reimbursement is only for someone who is maybe could be a prohibited source, but basically someone that's not a governmental entity providing you food and drink. Because normally you can't accept it because it's something of economic value, but there's an exception that says someone can provide you food and drink if you're in their presence and it doesn't exceed the 81.
Got it. Thank you.
Wait, hang on one
Oh.
second. Let me give you the microphone so they can hear you.
So on the, if I was an IT guy for the parish, right, or girl, and I retire and I go to work for a company that offers IT services, could that company come back and contract with the parish?
I would get Board of Ethics to sign off because they may be okay as long as you weren't involved in the contracts, but I would lay it out so they didn't have any questions that you were. I would have Board of Ethics give you a full sign off just to make sure, because if you have a situation where you're working for a company, but let's say you have an ownership stake, they may have an issue there.
But if there's no, if I was the head IT guy, girl, I retire, I go to work for a company, a small company that does IT services, can that IT services come back and contract with me being the provider?
If you're the actual provider of it, they're going to have issues with that because you're doing the services, you're engaged, you're contracting and getting because if you're doing the services, I guarantee you're getting compensated to do the services. They're going to most likely have an issue. But like I said, when those are going to be very fact specific,
Okay.
Board of Ethics is the only one that can tell you if that specific scenario is okay.
Gotcha. Thank you.
Wait, coming back. Getting my
your steps
workout
in.
today.
I'm very loud.
I know they got to hear you online. Through
It's
the
still
microphone.
online.
I have a stupid question, though. It's probably a stupid question.
There are no such thing as stupid questions.
Just out of curiosity, like I said, this is probably a stupid question. Does the Board of Ethics only apply to public agencies? Or
No,
does
there are restrictions. We didn't cover it here.
Yeah.
421117, I believe. Basically, there's basically it says a person cannot give, offer to give, lend, offer to lend, things that a person can't receive. So the person giving you something you can't receive can also be penalized. That's how they
Okay.
bring them in.
Okay, thank you.
And they don't even have to give it. If they offer to give it, it's a violation. think we're good.
Yeah.
Barry, we're good? Well, thank you all very much.